Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is my private Facebook group where you can come and join us. We're all fighting foreclosure, and we do share information with each other that's very helpful. Today we're going to talk about Bonnie, my friend Bonnie in New York, and her foreclosure situation and what she's doing. Let's take a look. Okay, so her case, if you look in a NYCEF, which is the NYSCEF, which stands for New York State Courts Electronic Filing System, you put in her case number, which is 604034-2023, and it's in Nassau County Supreme Court, the Bank of New York Mellon versus Bonnie Bisogno. That's the case title. Anyway, if you look at her case, I was looking through her docket of records and I found something interesting. If you look through all the things that were filed, you won't see a single entry that shows a notice of appearance by the attorneys. And the attorneys are required by law to file a notice of appearance whenever they do a motion or a complaint or anything. They have to file a notice of appearance, and they did not do that. So let's take a look at what that looks like. Let's use Carrington's case as an example. When Carrington's case was filed in 2009 on 5/709, you'll see his case number is 11234-2009, and you'll see what they filed their complaint on 5/709, and then they filed their notice of pendency, among other things, notice of appearance. Okay, and so a notice of appearance is required by attorneys to file. So let's look at what his notice of appearance looks like. It has the usual heading, and it just says, please take notice that Clairfield, Ocon, Salmon, and Pincus of this address, 114 Old Country Road, Suite 400, Manola, New York, hereby appears as co-counsel for plaintiff in the above caption case, blah, blah, blah. So you can see that they filed this and signed this and mailed a copy, of course, to the other side. And this is something that's required. And Bonnie's going to challenge that as we're going to see what she's filing. Let's take a look at her order to show cause, which she's filing today. So she's filing an emergency order to show cause. Let's take a look at this. Alright, so it says, please take notice that upon the affirmation of Bonnie Salzoni, defendant pro se, in support of this emergency order to show cause dated January 20th, 2025, and exhibits attached thereto, and upon all the pleadings, papers, and proceedings had herein, the defendant will move this court and the Supreme Court of Nassau County, 100 Supreme Court Drive in Manola, New York, on the date, and you can see there's blanks there for the judge to fill in. And it's saying to be heard for an order, correcting the caption, directing the caption of this foreclosure action be corrected to reflect Shellpoint as the true party plaintiff. Number 2, compelling filing of notice of appearance. Compelling the counsel for Shellpoint to file a notice of appearance pursuant to CPLR Rule 321. Standing, declaring that plaintiff lacks standing to continue the instant foreclosure action against defendant. Discontinuance, directing the plaintiff to discontinue the instant action as against the defendant. Other relief, granting such other and further relief as the court deems just and proper. Ordered that the plaintiff, the Bank of New York Mellon, as trustee for the CWALT Inc. Alternative Loan Trust 2006 HY13, be served a copy of this emergency order show cause and defendant supporting papers by overnight mail, which service shall be completed on or before, and then there's a blank, and such service shall be deemed good and sufficient service. Ordered that any opposition to the relief sought herein must be served upon the defendant on or before, and then there's a blank. And then there's a place for the judge to sign. And then here's the actual emergency order to show cause. Defendant Bonnie Salzoni, pro se, respectfully moves this court for an order to show cause why the caption of the foreclosure action should not be corrected to reflect Shellpoint as the true party plaintiff, and why counsel for Shellpoint should not be compelled to file a notice of appearance pursuant to CPLR Rule 321. And then there's a footnote. CPLR Rule 321 requires that any party represented by an attorney must ensure that the attorney files a notice of appearance in a timely manner. This notice is filed with the court clerk and serves to notify all parties involved of the court that the attorney is now part of the case. And of course they didn't do that. Defendant further requests that the court hear this matter on an expedited basis to ensure property party representation and procedural compliance in this case. Parties and procedural history. On 3/8/23, a foreclosure complaint was commenced in this instant action by Bank of New York Mellon as trustee for the CWALT Alternative Loan Trust. It is incorrectly listed as plaintiff, acting as trustee for the CWALT 2006 Trust. The defendant contacted Bank of New York Mellon and received a letter in the mail indicating that Bank of New York Mellon is not an interested party in regard to the loan. The letter directed the defendant to contact the servicer. A copy of this letter is attached here to as Exhibit A. Defendant then contacted Securities and Exchange Commission, the SEC, regarding the status of the CWALT Alternative Loan Trust by a Freedom of Information Act request. A copy of this request and response is attached hereto as Exhibit B. The SEC explained in the response that the CWALT Alternative Loan Trust filed a Form 15 which indicates their status being dissolved on January 29, 2007. Shellpoint, the loan servicer, is the true party bringing the foreclosure action on behalf of the trust. However, the trust no longer exists. The attorney for Shellpoint, Kevin Butler, of Friedman Vartola, has not filed a notice of appearance in this case as required by CPLR Rule 321. Legal argument. The caption must reflect the correct party in interest, which is Shellpoint, not Bank of New York Mellon. CPLR Rule 321 mandates that attorneys representing a party must file a notice of appearance to formally enter the case. The attorney for Shellpoint has not done so. The court has the authority to amend the caption to reflect the correct party and to compel compliance with Rule CPLR 321, which requires the attorney for Shellpoint to file a notice of appearance. Relief requested. Correct the caption. Plaintiff respectfully requests that the court correct the caption to name Shellpoint as the true party plaintiff and proper party in interest. Order. Filing a notice of appearance, plaintiff requests that the court direct Kevin Butler of Friedman Vartola, representing Shellpoint, to file a notice of appearance in accordance with CPLR Rule 321. Expedited hearing. Plaintiff requests that the court schedule a hearing on this order show cause at the earliest possible date to ensure timely resolution of these procedural issues. Conclusion. For the reasons stated above, plaintiff respectfully requests the court grant relief requested in this order show cause and to take other such action as the court deems just and proper. And then she signs it, and then there's, of course, affirmation of mailing where a person besides herself attests to sending a copy to the other side. And that's that. Okay, so let's take a look at her attachments real quick. Okay, so the first one was her Bank of New York Mellon letter that she got, and she sent me a copy to look at. And as you can see right here, it says, "Thank you for your recent correspondence. Bank of New York Mellon is acting as a trustee, and therefore we do not own the loan or the property. As trustee, Bank of New York Mellon is not involved in the servicing of the loans or the foreclosure process. This is the responsibility of the servicer. Since Bank of America services the loan associated with your property, they are the direct and only contact in regards to request." Okay, and it says I forwarded your email to them. Well, we know Bank of America is no longer, and I don't know why they sent that information to her unless they changed hands so many times. But anyway, as you can see, they're saying they don't have anything to do with it. So let's take a look at the next thing, and that would be the next thing that she filed, which would be the, let's see, the FOIA request to the SEC. It's just a typical FOIA request to the Securities and Exchange Commission. FOIAPA@sec.gov is the email address in case you guys want to ever send a FOIA request to them. I am seeking information regarding a trust called the CWALT Alternative Loan Trust 2006 HY13 to determine if the trust still exists. I did find some information on the SEC's website, which states it filed a Form 15 dated January 29, 2007. I have copied and pasted information in this email for you to confirm. And basically she sends that, and then they send her this, which is the Form 15. And it does state that they dissolved on that date, January 29, 2007. So there's that. Okay, so as you can see what Bonnie's trying to do, she's trying to get the caption of her case changed so that the servicer is actually the plaintiff and not the Bank of BNY Mellon. And by doing so, if they change the caption and they show Shellpoint as the plaintiff, then they don't have standing to foreclose. As you know, the servicer that doesn't own the underlying loan, they only service it. So then she could have this case dismissed because of lack of standing. So I thought you guys would think this is an interesting way to go about it. And she's certainly going to try to do it because, as you can see, they never filed a notice of appearance anywhere in this case. And I did look 3 or 4 times just to make sure they didn't do it, and they didn't. So we'll see what the judge does. Okay, guys, if you have any questions about this, you can certainly send me a text message or an email, and can join us over on my Facebook page. And if you have any questions, just leave them in the comment section below. And as always, everyone have a blessed day and stay warm. Okay, let's